Hello students. The last class we saw negligence. Uh, right now you are well aware of the concept of negligence. What is negligence under the law of torts? Now we are heading towards contributory negligence. All this time we saw where negligence will be caused by the or the act of one will be failing from his duty, where the defendant would have failed from his duty and the plaintiff may file a case seeking for a compensation. But now we are heading towards a case where the plaintiff himself is equally responsible for the suffering which he is facing right now. It is not only the defendant's fault, it is also the plaintiff's fault. Is the principle which under which we are going to discuss the concept of contributory negligence. And with regards to this contributory negligence, to explain this contributory negligence, there is a case called as Rural Transport Service versus Bezium BB. In this case, the conductor of an overcrowded bus invited passengers to travel on the roof of the bus. The driver ignored the fact that there were passengers on the roof and tried to overtake a cart. As he swerved the bus on the right for the purpose and went on the Kachar road, a passenger sitting on the roof was hit by the branch of a tree. He fell down, received severe injuries, and then died. It was held that both the driver and the conductor were negligent towards the passengers who were invited to sit on the roof. There was also contributory negligence on the part of the passengers, including the deceased, who took the risk of traveling on the roof of the bus. So it is now very clear. Even at our homes, they will ask you, if your friend says, where is your common sense went? Why you have not applied your mind? Similarly, in this case also, the bus was overcrowded. The conductor of the bus invites the passengers to sit on the top of the bus. And the passengers are also interested to sit on the top of the bus, and because of that, they went to the top of the bus. And all of a sudden, when there was a difficulty for the driver to ride his bus, he took a right and he entered into a Kacha road, and because of the all of a sudden the road bent, there was a tree, branches of the tree which was there in the upstairs, and the passengers who were sitting on the top hit by the tree and they suffered injuries. Now when the driver and the transport corporation is sought for compensation for the work of for the act of their servant, vicarious liability principle, the court says, of course, true, the driver and the conductor has committed mistakes, and the conductor specifically has committed mistakes by inviting passengers to sit on the roof of the bus. But why did the passengers also boarded and sat on the roof of the bus? Because the passengers should have also taken due care when it comes to their life. So this is where they say both the conductor as well as the passengers are equally responsible, and this is so they both are equally responsible. So the compensation will be calculated and will be given based only on the carelessness which the conductor has rendered in his part. For that alone the compensation will be calculated. This is with regards to contributory negligence. To understand this concept of contributory negligence, you can see a video. I'll display a video to you, and this will make you very clear uh, what we are trying to say under the concept of contributory negligence.
In this video, we will discuss comparative negligence. A plaintiff's damage reduced or even eliminated based on the percentage of his own carelessness. Let's say Perry is being careless by playing a video game as he crosses a street. Here comes David, who is going too fast on his skateboard while listening to music. And David slams into Perry. Perry has $100,000 in damages and sues David. And let's say the jury decides that David is 60% responsible for the accident, and Perry is 40% responsible for the accident. The jury decides that Perry was also careless. Perry's own carelessness contributed to the accident. And the traditional rule of contributory negligence would be that Perry gets nothing.
So here you could see that in this case, where the plaintiff, because of his contribution, he is not receiving anything as a written. So this, how long this particular principle can be accepted, that was the issue. And based on that, they introduced a new concept called as contributory negligence. During assessing contributory negligence, the defense should be in this way, or the court should look into who was responsible, or who is responsible to eradicate a particular act, or who had the last opportunity to uh, prevent this particular incident or the accident. So that is where the court came for a new principle called as the last opportunity rule. So with this I conclude. We'll proceed with the next class. Thank you so much.